Mr. Riley refused to submit to your analysis, had to be put in the chair because he was banging his head and being, trying to hurt himself, and so gonna go ahead and have him. And he did admit also,
Smoking marijuana last
to at least smoking marijuana last night, if not anything else, so we'll go forward that way. Okay. Mr. Smith? Is Mr. Smith here? Who's Mr. Smith today? On Lisa Pratt?
Excuse on the screen.
Yes, sir, thank you. Yes, correct. That's to do this, get the pre-sentence report done. Do you mind signing that for him, please? All right, ma'am, you're Lisa Pratt, and will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Pratt, in cause number, no, I have me pull the right one up, I'm sorry.
Move dams for the water.
Okay. And are we just going on count one with the, and
We are, Your Honor.
okay. Ms. Pratt, in cause number 24 DCCR 1460, the state's elected to proceed on count one only. It alleges that you committed the state jail felony offense of theft of property with previous convictions from April 1st of 2024. It further alleges that you were previously convicted of theft June 30th of 2023 in two different cases on that same date. And how do you plead to that charge? Speak up.
Guilty.
Are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And the agreement that you've reached, it looks like it's for a 12-month term in the state jail prison. And you guys have asked me to reset your case for sentencing for a short amount of time so that you can have a final appointment with regard to the issue on your leg or your knee. Is that correct? Or ankle? Ankle. I want to make sure you understand. How long, when's the next appointment?
August the 20th or something. Yeah.
Ma'am?
It's not till August.
Okay.
You said August 24th.
I might can get it moved out. I mean, I don't know how it falls. Today's the way.
All right. You're thinking. Okay, so I'm going to state tenders number 1.
No objection, Your Honor.
It's admitted any evidence that Ms. Pratt is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yeah.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing. I don't need a pre-sentence report. And I will reset it to the, August the 31st. It's a Monday. There's a few things that are very important about that. So if you are arrested for anything between now and that court date, I do not have to accept this plea agreement. Things could obviously be worse. Do you understand?
I do.
Also, if you don't show up for that court date, obviously things could be much worse. I don't have to accept the plea agreement. You understand as well? All right, then, we will see you back at sentencing. You're free to go.
Thank you, Your Honor.
Good morning, Judge. How are you?
Good. Good morning, ma'am. Are you Alexandria De Leon? This is 26 DCCR 0143. Ms. De Leon is charged with assault on a peace officer. And what is the announcement?
Your Honor, we need one more reset. We have something verbally worked out. We're getting a few letters of recommendation to turn over to the state as part of the plea agreement. And also I'm waiting on a letter from Mr. Green that should be taken care of next month.
All right, so we'll just do a normal reset and Ms. De Leon, make sure you stay in touch with, it looks like you were just hired in May, correct?
Judge.
Yep, so we'll just do a normal reset, give you some time to get all that taken care of, and we'll see if we can get an announcement the next court date.
Thank you, Judge.
Thank you. Is there paperwork on this one?
He's just pleading true to count one. So I was gonna do paperwork, but we didn't come to an agreement. I did send the appellate.
Did you send me something on that? I'm sorry. I didn't-
Yeah, I sent the appellate certification.
It's here, I've got it. Mr. Nichols, it goes straight here. All right, so are you Angel Mata Rodriguez?
Yes.
And will your client waive the formal reading of the motion?
He will.
Mr. Mata Rodriguez, in cause number 23, DCCR 1106, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2023 for the third-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 5-year deferred probation. Is that correct?
Correct.
And it alleges that you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated with an open container, March 22nd of 2026. And is that true or not true?
Oh, true.
I'm sorry,
True.
true. Count 2,
We just want to award that.
not if it's unagreed.
Oh, okay. That's true. You're right. Sorry.
Count 2 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you became intoxicated March 22nd of 2026. And is that true or not true?
True.
And then count 3 alleges that you are behind in your court assessed fees as of April 29th of 2026 in the amount of $710. And is that true or not true?
Oh, not true.
Okay,
No, it's as of that date, not now.
Oh, was it? Okay, true.
it was true as of
Sorry.
that date. Okay.
Yes,
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
correct,
And did you plead true to those counts because they're actually true?
correct.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that the probation department can do an updated report, and we will come back for a sentencing hearing. Anything you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back for sentencing.
Yes, ma'am.
And make sure do you need to talk to him today? Okay, just stay in touch with your probation officer. Yes, sir.
I have one question. I know I have the ankle monitor. Is there any way I can get a patch instead of monitoring?
The patch doesn't do alcohol. Yeah, so that's why you've got the SCRAM device on, is because that's the one that tests for alcohol.
Okay.
Okay, so at least until sentencing, we're gonna keep it the way it is.
Yes.
Okay, all right, we'll see you back at sentencing. And you are Deshawn Robertson?
Yes, ma'am.
And Ms. Robertson is charged with aggravated assault with a deadly weapon, and there is a motion to modify or delete a bond condition that was filed with regard to
It's,
not driving a car.
correct, Your Honor.
And Your Honor, we've discussed it. I've looked at it. I don't have any opposition to letting her drive for those limited reasons that were requested.
These are regular NHMR appointments, Your Honor. These are any doctor appointments for her youngest child who's still in school. Her youngest child goes to school near Nederland, Texas, away from here in North Beaumont, where she currently lives. And she's also on GPS and employed, Your Honor. GPS is current as well.
The reason the driving was added at the beginning, Judge, was the assault involves hitting someone with a car.
Okay. So let's get.
It wasn't an intoxication situation. Your Honor.
Okay. So you are working or you're not working?
Yes, ma'am, I'm working.
Where do you work?
I work at Rose's. I'm a customer service manager.
At Rose's?
Yes, ma'am.
Where's that?
On Concord in Beaumont.
And where do you live?
On Thames Street in Beaumont.
THAMES?
Yes.
Thanks. It's just the order setting a hearing. Oh. And your child goes to school where?
At Evolution Academy.
All right, Mr. Nichols, you have no objection.
I don't, Your Honor. I reviewed his motion. We discussed it over the last few days and I don't have opposition to lifting those conditions.
The MHMR is at the Spindletop location as well, Your Honor.
Right.
Sorry, my apologies.
Yep,
I keep forgetting.
and that's in Beaumont.
Correct.
Oh.
Yeah, let's go. Spindletop.
Okay, so here's what I'm gonna do. I'll grant the motion to modify the condition. I am going to allow you to drive. It's still gonna be for limited purposes though. So it's gonna be go to work, take kids to school, and go to any medical appointments, either doctor or medical through Spindletop, right?
Yes, ma'am.
That's it.
Yes, ma'am.
Other than that, you need to be at home.
Yes, ma'am.
Okay, and not driving around town and obviously not having any contact at all with the complaining witness that we've already talked about.
Right.
Okay,
Yes, ma'am.
anything else?
Nothing.
Okay,
Not at this point, Judge.
okay. All right, then I'll just reset your case for an announcement, give you some time to get all of the evidence. Make sure you visit with your attorney before all the discovery. Make sure you discuss all of that with them before that next court date, see what the announcement is.
Thank you, Your
All
Honor.
right, you're free to go.
What happened in this courtroom was a reminder that every decision comes with consequences. From a guilty plea and a 12-month sentence hanging in the balance, to probation violations and strict conditions on the road, the judge made it clear that second chances come with limits. And in the final case, one restriction was changed, but only under very specific conditions. What do you think about the judge's decisions in these cases? Let us know in the comments, and if you want more real courtroom moments and legal breakdowns, make sure you subscribe and turn on notifications.